You know, there's this quote that says capitalism's process of creative destruction continually creates the risk that legal rules will lag behind economic reality. And lawyers, well, they're called upon to either exploit or fill that gap. That's a pretty powerful thought, right? Because when the business world is just evolving at absolute lightning speed, the rulebook literally can't keep up. And caught right smack in the middle of that chaotic gap are corporate lawyers, just frantically trying to navigate between lagging legal frameworks and fast-paced economic reality.
So, welcome to This Explainer. Today, we're going to dive into a really fascinating piece from the Georgetown Journal of Legal Ethics by Milton C. Regan, Jr. We're going to decode the incredibly complex and honestly sometimes totally contradictory ethical tightrope that modern corporate lawyers have to walk every single day. It's this massive story of shifting loyalties, giant bureaucracies, and a legal system that is seriously struggling to adapt to global capitalism.
To help us wrap our heads around this massive shift in the legal world, we're going to break things down into 6 clear themes. We've got the evolving legal workplace, figuring out who the real client is, deals versus disputes, independence versus the team, global gatekeepers, and finally, the multidisciplinary future. Let's get right into it.
All right, starting off with Section 1, the evolving legal workplace. So the old law firm model, it was built on secure, really long-term relationships. It was very much a generalist's game, where your seniority pretty much meant a secure, lifelong partnership. But today, the new model is a whole different beast. Corporations have brought a lot of their everyday legal work entirely in-house, which means they now only hire outside firms for incredibly specialized expertise. And that has created just intense competition. Partnerships nowadays are often merit-based, tiered, and above all else, driven by business generation. Making partner isn't a guarantee of lifelong tenure anymore. Look, if you aren't bringing in the dollars, your seat at the table is absolutely at risk. And as you can imagine, this immense pressure completely changes the incentives for how a lawyer approaches their work and their clients.
Which brings us right to Section 2. Who is the real client? Now, according to Model Rule 1.13 of professional conduct, your client actually isn't the CEO sitting across the desk from you. It's not the board of directors either. The client is the corporate entity itself. It's literally an abstraction. The lawyer represents this invisible entity acting through its authorized constituents. And you can see how this creates an immediate ethical dilemma, right? You're interacting daily with managers who speak for the corporation, but you can never, ever mistake those actual individuals for the entity itself.
And modern corporate bureaucracy actually makes this even harder by fragmenting information. Imagine you suspect a manager is acting against the company's best interests. To actually do something about it, you need to firmly know that misconduct is happening. But in a sprawling global corporation, knowledge is scattered all over the place. One office has a piece of the puzzle, another office has a totally different piece, and the lines of authority are incredibly blurry. More often than not, no single person actually has the complete picture. And let's be honest here. Sometimes there is a diligent avoidance of unpleasant facts. It's a kind of willful ignorance. This whole setup makes it incredibly difficult for a lawyer to pinpoint actual misconduct, or to know when they actually have enough solid ground to challenge a powerful corporate decision-maker.
Moving on to Section 3, deals versus disputes.
So, here's the crucial point to remember. Our traditional ethical rules were mostly formulated with the courtroom litigator in mind. Litigation involves strict judicial oversight and really stringent disclosure duties to protect the integrity of the court. But a massive chunk of modern corporate practice isn't litigation at all. It's transactional work. It's making deals. And in negotiations, there's no judge sitting there watching you. Disclosure obligations are way more relaxed, basically just relying on common law fraud standards, which, essentially just means you can't outright lie. But how much do you actually have to reveal to the other side? If you push those boundaries too hard in transactional work, it can create this downward spiral of aggressive tactics. That ends up increasing costs and really lowering the overall expectation of fair dealing across the entire market.
And that dynamic leads us perfectly into Section 4, independence versus the team.
Increasingly, lawyers and especially in-house counsel are expected to be proactive, meaning they're supposed to be framing business strategy right from the ground up to anticipate and prevent issues, rather than just sitting back and saying yes or no to a plan that's already finalized. But think about what this actually does. Traditional legal ethics always assume a bit of distance between the client, who sets the goals, and the lawyer who figures out the legal means to get there. But when the lawyer becomes a fully integrated team member, actively helping to formulate the very business goals of their only client and employer, that line completely blurs. It becomes incredibly hard to step back, put on your objective legal advisor hat, and tell your own team that their brilliant new strategy just crossed an ethical line.
Let's zoom out a bit for Section 5, gatekeepers in a global world.
Modern business doesn't really care about borders, but the law definitely does. When a single corporate transaction crosses multiple countries, lawyers get caught in a totally wild thicket of conflicting ethical rules. For example, the European Court of Justice determined that attorney-client privilege doesn't always apply to communications with in-house counsel during certain European Commission proceedings. Imagine being an American in-house lawyer, totally accustomed to absolute confidentiality, and suddenly finding out that your emails to your European subsidiary might not be protected. I mean, wow! It creates just massive unpredictability for anyone engaged in transnational practice.
And it's not just geographical borders we're talking about, it's regulatory ones too. State bar associations used to be the only real sheriffs in town when it came to legal ethics. Well, not anymore. Powerful federal agencies have heavily stepped into the arena. The SEC has argued that lawyers have an actual obligation to prevent clients from making deals with insufficient disclosure. Tax lawyers are facing stricter standards of good faith from the IRS. Bankruptcy rules impose incredibly harsh disclosure requirements. The point is, corporate lawyers are increasingly being drafted into this role of quasi-public gatekeepers. Regulators expect them to restrain client misconduct, which obviously creates immense tension with the traditional idea that a lawyer's sole absolute loyalty is supposed to be to their client.
Which brings us to our final part, Section 6, the multidisciplinary future.
As the American Bar Association and other global entities debate whether lawyers and non-lawyers should be able to partner up and share fees, there is a massive, fundamental ethical clash right at the heart of the issue. Look at this dynamic. Lawyers are bound by stringent duties of confidentiality. Their primary role is to be an advocate, but accountants and auditors, they are bound by strict obligations of disclosure. Their entire role is to be a public monitor attesting to financial accuracy. So, how on earth do you put those two professionals under the exact same organizational roof? If a client admits to a financial irregularity, the lawyer's instinct is to keep it completely secret, while the auditor's sworn duty is to report it. It's a literal collision of professional cultures.
So, how do we actually solve these incredibly tangled conflicts of interest, especially as these firms merge into just massive global behemoths? Well, one proposed solution, highlighted in our source material, comes from Professor Richard Painter. He suggests allowing sophisticated corporate clients and their attorneys to use advance waivers. Essentially, they would sit down right at the start of their relationship and contractually agree on exactly which future conflicts will or won't get the lawyer disqualified. The thinking is, since both the mega corporation and the mega law firm are highly sophisticated players, why not let them write their own rules of engagement? It could definitely provide some much-needed predictability in a landscape that is, right now, just a total minefield.
But even if we allow sophisticated contracts to sort out some of these technical conflicts, a much deeper philosophical issue remains, and it's this. Do lawyers have a quasi-public duty to stop clients from exploiting every single legal advantage, or does their loyalty belong solely and completely to the corporation? Look, the integrity of our legal system is a vital form of social capital. If lawyers just help powerful corporations opt out of the spirit of the law by exploiting every possible loophole, the whole system breaks down. Yet, their very own ethical code demands fierce, unwavering loyalty to the client. Finding that perfect balance between private advocacy and public duty in this modern, hyper-competitive, globalized world, that is absolutely the ultimate test for today's corporate lawyer. What do you think they should prioritize? It's definitely something to chew on. Thanks so much for joining me on this explainer today. Keep questioning, keep learning, and I'll catch you next time.